Good afternoon, folks. Welcome to our program today. We're going to continue our monthly series on different health law issues. Today, we're going to be talking about different health information issues, particularly HIPAA Part 2 and the information blocking. I'm Kim Stanger. I'm the head of the firm's health law group, and I am a self-proclaimed HIPAA guru. Well, not necessarily a guru, but certainly a HIPAA nerd when it comes to this type of stuff. So, a couple of preliminaries because we have a lot to cover today. Remember that because we have so much to cover, this is going to be an overview of the things that we need to address. So when it comes time to actually applying the things that we talk about today, make sure you pull out the regulations, take a quick look, and also remember any particular state laws or other laws that may apply in your particular situation. And remember that the application may vary depending upon the circumstances. For those of you who opened the PowerPoint slides and saw that we have, I think, right about 100 slides in the presentation today, don't choke. I'm not going to go through all of those slides. I ultimately decided to go ahead and leave those slides in so that you had them as a resource in case you need them, but I'm going to go through it pretty fast. If you didn't receive a copy of those slides, just shoot an email to Cindy, and she can make sure that she gets those to you. We're not going to take questions during the program today because the session is going to be recorded. But if you have any questions, feel free to go ahead and submit those using the chat feature, and you can email those to me and I'll respond offline. With that said, let's launch into it. Today we're going to be talking about those conflicting laws, potentially conflicting laws. Remember that when you're dealing with HIPAA, the information blocking rule, or Part 2, as well as state laws, they may not all jibe. They weren't all written at the same time. They don't all necessarily cover the same things. And so you may have conflicts between the two. For example, the information blocking rule generally is going to require you to make disclosures sooner than the HIPAA rules would. In contrast, the 42 CFR Part 2 has a lot of changes that are different than HIPAA. The key there is to remember that when you're applying these laws, make sure that you comply with the most restrictive law, which HIPAA defines as the law that gives the greater protection to the patient or the law that gives greater control of their information to the patient. Normally, 42 CFR Part 2 in most instances is more strict than HIPAA, so you'd have to comply with the requirements in Part 2. But there are some situations where HIPAA is more restrictive or requires additional things, and therefore you'd have to comply with those additional things. Let's talk first about HIPAA issues. I know you're all familiar with HIPAA, so I'm really going to just kind of give a brief overview of kind of the main points and focus on maybe some of the problem issues that I see arise quite frequently, as well as give you a few updates of some of the things that's happened with HIPAA along the way. The first is, remember that you may not have known that under HIPAA, you can actually go to jail for a HIPAA violation. There's a criminal penalty statute associated with that applies to any individuals who obtain or disclose protected health information without authorization. The penalties are anywhere from 1 year in prison up to 10 years in prison, and from a $50,000 fine up to $250,000. I find this statute really helpful if I need to get an employee's attention who simply isn't paying attention to HIPAA. If we need to get their attention, we can warn them that, hey, you could be subject to criminal penalties. You may not be worried about the civil penalties, but you could go to jail for this, and there have been people that have gone to jail for this. It's also helpful if you may have a situation where somebody outside your organization has improperly received information and you want to make sure that you're mitigating that disclosure, and therefore you're going to notify them that, hey, you shouldn't be using this information, and don't disclose it further, because if you do, you can get hit up with these criminal penalties. Most of you, though, have to be more concerned about the HIPAA civil penalties. And the way that HIPAA penalties work, there's a tiered structure. The amount of the penalty depends upon the conduct that's involved. If you did not know and should not have known of the violation, or the violation was due to reasonable cause, then the penalty is anywhere from $127 to about $64,000 per violation. Those are subject to a cost of living adjustment, so it goes up each year. Those are the most recent adjustments. On the other hand, if you act with willful neglect, then you don't correct, you correct the situation within 30 days, the penalty is anywhere from approximately $13,000 up to $65,000. But the key here is that the penalty is mandatory. If you don't act with willful neglect, then the penalty is not mandatory. You may be able to avoid HIPAA penalties if you correct the situation within 30 days. Now, But if you act with willful neglect, then the penalty is mandatory. The OCR would have to enforce those penalties. Now, that's if you correct it within 30 days. If you fail to correct it within 30 days and you act with willful neglect, it's a mandatory penalty of about $64,000 up to about $2 million per violation per year. So you want to make sure that you're not acting with willful neglect. And remember also that the number of violations can add up awfully quickly. Because if, for example, you lost an unencrypted laptop and you think that it's been improperly accessed, then and that laptop contained 2,000 patients' information, that could be 2,000 separate violations. So the penalties can add up really quickly. Again, the key there, make sure that you are up in the area where you are not acting with willful neglect so you can potentially avoid the penalties. How is the government going to catch you? Well, you have to self-report. You have to narc on yourself. We'll talk about that later. An important factor here is under the HITECH Act, when HITECH was issued, they proposed to give individuals who suffered damages or were injured because of HIPAA violations, that HITECH would allow them to recover a percentage of the penalty. So it kind of gives them a bounty or a bonus if they were the victims of improper HIPAA breaches. Now, we had not received, or still haven't received, the implementing regulations, and that's kind of just been sleeping. We were hoping it was a sleeping dog and we weren't going to wake it up, but apparently it has woken up. On April 6th, HHS issued a request for information about soliciting input about how those penalty structures should work. So we can anticipate that that's going to be coming down the line. So before too long, I anticipate that patients or others who are affected by HIPAA breaches, that they're going to be able to recover a percentage of those fines and penalties, which is going to create an incentive for them to bring HIPAA complaints and allegations against you. So watch out for that. It's a good time to make sure that you are complying with HIPAA. As I mentioned, however, the good news is you can likely avoid HIPAA penalties, civil penalties at least, if you do certain things. And this may be the most important slide I show you today. You want to make sure that you've got the required policies and safeguards in place, that you execute appropriate business associate agreements, that you train your personnel and document your training, you respond immediately to mitigate and correct any violation, and you timely report breaches if breach reporting is required. The government has indicated that if you did everything you could do and you simply have a rogue employee who goes off and makes improper disclosures, the government has said, well, that's not willful neglect on your part. You may have had a HIPAA violation, but if you correct it within 30 days, then that is an affirmative defense to HIPAA penalties. That rogue employee may be liable to criminal or civil penalties, but you as an entity, as an employer, shouldn't be liable as long as you did these items up here. So you want to make sure you're doing those things and you document it so that you can avoid any of those willful neglect issues. So let's talk about some of the nuances of HIPAA. Obviously, HIPAA applies to healthcare providers, but it's not all healthcare providers. It's only those healthcare providers who engage in certain electronic transactions. If you're not engaging in those electronic transactions, primarily dealing with third-party payers, then you can avoid HIPAA. You may still have obligations under state privacy laws and the like, but HIPAA would not apply to you. Doesn't apply, or that exception really wouldn't fit most of our healthcare practices out there. So most of you are going to be covered. Make sure that you beware hybrid entities. You've got an entity, maybe you've got a clinic operating in a bigger factory. If that clinic is submitting those claims to payers using these electronic transactions, then that clinic is going to be covered by HIPAA. And unless you've taken steps to establish a hybrid entity or segregate those responsibilities, the entire entity could be subject to those HIPAA obligations. So make sure you keep that in mind. Also, quick note, remember HIPAA not only applies to healthcare providers who engage in those electronic transactions, it also applies to health plans, which are any employee group, well, which includes any employee group health plan if it has 50 or more participants or is administered by a third party. So a lot of you, if you work for a hospital or the like, the hospital has to comply with HIPAA not only as a provider, but its health plan would also have to comply with HIPAA. So don't forget about the health plan requirements. The government has not been active enforcing those against health plans, but it's possible that it could come down the pipe, so just remember that. Remember, the HIPAA only applies to protected health information, which is very broad. It generally concerns any information received or created by a healthcare provider or health plan acting its capacity as such. that relates to the past, present, or future of physical or mental health, healthcare, or payment for their healthcare that either identifies the individual or, this is what I wanted to emphasize, with respect to which there is a reasonable basis to believe that the information can be used to identify the individual. So even if you don't include the individual's name in there, if there's still enough information there that somebody else could use that information to identify the individual, then in that situation, it's going to be considered protected health information if it's linked back to the individual's health care. And it's not just their particular clinical records, it's anything that suggests that they received health care, even if it's not specific. It's helpful to remember that you can avoid HIPAA if you go in and you de-identify that protected health information, if you suck out all of the identifiers. And the government has identified those factors that you have to remove in order to be deemed to have de-identified that information so that it's no longer identifiable. I bring that up because these are the types of things that the government indicates are identifiers, right? Things like certainly names, but dates, telephone numbers, social security numbers, account numbers, those types of things. If that's left in the record, even though the patient's name's not in there, then there's a good chance that that's going to be considered to be individually identifiable, and HIPAA is going to apply to that record. I get a lot of situations where I got a question the other day. Somebody said, well, we just sent, we text back and forth account information. We don't include the patient's name, but we'll include the account number. And I told them, well, gee whiz, that's probably still protected health information, and therefore you need to make sure those texts comply with the security rule like we'll talk about in a little bit. Let's talk about the use and disclosure rules. They can be summarized as follows. When it comes to HIPAA, don't access information if you don't have a need to know. Remember, HIPAA not only applies to the internal disclosure of the information or the external disclosure of the information, it also applies to your internal use. So your people shouldn't be accessing that information if they don't have a need to know. And if they are accessing it improperly, that is probably a HIPAA violation. Don't disclose the information outside your organization unless you've fit an exception or have a HIPAA compliant authorization from the patient or the personal representative. And you got to make sure that you implement reasonable safeguards. So general rule is you can't use or disclose the patient's protected health information unless you have the patient's written authorization or you fit within the HIPAA exception. Let's talk about some of those exceptions. The first one, the biggest one that you all know and love, you can use or disclose the patient's information for purposes of treatment, payment, or healthcare operations. Okay? And you don't need the patient's authorization to use or disclose it for treatment, payment, or healthcare operations. A couple of points on this. Healthcare operations is not just anything you're using in the organization. Healthcare operations is a defined term within the regulation, and it's not everything you do. So before you rely on that healthcare operations exception in order to justify what you're doing, make sure you look at the definition of healthcare operations to make sure it really applies. Also, you can use or disclose the information for treatment and payment, not only for your own purposes, but also for another covered entity's purposes. So you can disclose it for their treatment purposes or their payment purposes. But when it comes to healthcare operations, you're limited in the amount of information or the type of information that you can provide to that other entity. You can only provide it for certain purposes, certain healthcare operations purposes, not all purposes, and then only if you have a mutual relationship with the patient. Remember that this exception for treatment, payment, or operations does not apply in two important situations. One is psychotherapy notes, which isn't just mental health records. It's a very defined term under HIPAA. Also, it doesn't apply if you have agreed otherwise with a patient to limit your use or disclosure for treatment, payment, or healthcare operations. This is an important point I wanted to emphasize. HIPAA says you don't need the patient's authorization as long as your use or disclosure is for treatment, payment, or healthcare operations. But if you tell the patient that, hey, we won't disclose any of your information unless you authorize us to, well, now you can't use it or disclose it for treatment, payment, or healthcare operations without the patient's consent. So for heaven's sakes, don't tell the patient that you're going to limit your uses or disclosures for treatment, payment, or healthcare operations, or make these broad sweeping statements that we won't disclose their information without your consent. Look at your consent forms, look at your other documents, make sure that you're not including those types of statements. If you are going to include any statements like asking for a list of patients to whom you can disclose the information, make sure you at least put in some kind of a disclaimer on there that says, but we are not waiving by identifying these people, we are not waiving our right to disclose or use information for treatment, payment, or healthcare operations is otherwise permitted by HIPAA. Another exception allows you to make user disclose protected health information, to make disclosure to family or others involved in the patient's healthcare or payment for their healthcare. So this is the one that allows you to disclose to friends or family, right? But it doesn't automatically allow you to do that. You can only make those disclosures to friends or family if the patient consents to it or does not object, and they were in a situation where you could expect them to object if they did, like they invite the family member into the room, or they know that the family member is involved in paying the bills, or those types of things. If the patient's present, you can only make that disclosure if you get their consent, or it's reasonable under the circumstances to assume that they haven't objected. If the patient's not present or unable to consent because they're incompetent or whatever, then in those situations, you can only make those disclosures if that disclosure you think it's in their best interest and it's consistent or not inconsistent with their prior expressed wishes. And then you can only limit, you have to limit the amount of information you disclose to those friends or families to the scope of their involvement in the patient's care. In the omnibus rule that came out in 2013, they broadened this exception to say that it also applies to disclosures after the patient dies. So after the patient dies, you can still make disclosures to friends or family who are involved in the care prior to the patient's death, so long as you satisfy these criteria. HIPAA has an exception that allows you to use or disclose information for your facility purposes to identify a patient within your organization, but it only allows you to disclose very limited information, including the patient's name, their location in the facility, and their general condition. And you can only do that if the requester asks for the patient by name. So it's a very limited exception. There are a whole list of exceptions under 164.512, including HIPAA would allow you to make disclosures to the extent another law requires the disclosure. The key word there is the law requires the disclosure. If another law simply allows you to make disclosure, then under at least the commentary that accompanied the omnibus rule, HIPAA would say you can't make that disclosure. That exception doesn't apply. So for example, in Idaho, where I live, the legislature passed a law that said that physicians may, if a patient looks like they're having trouble driving, they can make a report to the DMV, the Department of Transportation, or the Department of Motor Vehicles. Well, that statute allows the physician to make the disclosure. It doesn't require them to make the disclosure, and therefore HIPAA would trump it, and therefore that statute really does no good, because under HIPAA, it says you can't make that disclosure unless the law requires it. You'd have to look for another exception. There is an exception under HIPAA that allows you to make disclosures to prevent a serious and imminent threat of harm. Now, in 2021, the government proposed changes to HIPAA. One of the changes that they proposed was to ratchet back and make it a little bit easier to make disclosures to avert imminent harm situations. And they kind of ratcheted back and they've reworked that so it's not necessarily limited to serious and imminent harm. We don't know whether that proposed rule is going to go through, but we'll keep an eye on that. There's exceptions that allow you to make disclosures to Public Health Act for public health activities like abuse reporting or reports to your local health department for COVID and things like that. There's an exception for health oversight activities, exceptions for judicial or administrative proceedings, including responding to court orders or warrants or subpoenas. Just realize that the rules differ depending on the type of subpoena you get. So you want to make sure you look at those rules. We're not going to go through those today, but the rules differ depending on the type of subpoena that you receive. There's disclosures that are exceptions that allow you to make disclosure to law enforcement, but it only applies in limited circumstances. So before you disclose that information to the police, you got to make sure that they fit within one of the specific exceptions for those disclosures, and those exceptions have been satisfied. There are other disclosures for workers' compensation, for disclosures to the armed forces and things like that. The key there is, before making those disclosures, check with your privacy officer, look at the rules, and make sure you're satisfying all of those requirements. Unless you fit within one of those exceptions, like treatment, payment, or healthcare operations, or disclosures to family or friends, or disclosures under 0.512 for certain public safety or to public agencies, unless you fit within those exceptions, the general rules, you have to have the patient's written HIPAA compliant authorization. And that authorization has to contain the elements that are required by HIPAA. Again, we're not going to go through those today, but you may want to periodically look at your form authorization and compare it to the requirements in 45 CFR 164.508 to make sure that your authorization is still compliant. Among other things, that authorization cannot be combined with any other document. It's got to contain required elements, and it's got to contain certain required statements. Let's talk about a couple of issues that come up. One that was kind of a hot topic during the ongoing COVID problems is if you are vaccinating your employee. Questions come up about, well, can we share information or use that information for employment-related decisions? Well, anytime if you're a healthcare provider and you're acting in your capacity as a healthcare provider, including administering healthcare to your employees, then HIPAA is going to apply to that information, which means you can only use it or disclose it if you're allowed to by HIPAA, which generally means you would need the employee's authorization, or you would have to have another HIPAA compliant exception that would allow you to use or disclose their information, that health information that you got concerning the employee. You'd have to have an exception that would allow you to use it or disclose it for employment-related purposes. I know that's a shock to some of you, but the government has issued commentary specifically addressing that situation. So when you're involved in things like doing employee physicals, when you're doing your own employee vaccinations, when you're doing employee drug screens, where you're doing independent medical exams, those types of things, you may not think that you're acting as a healthcare provider, but under HIPAA you are. And therefore, you can't use or disclose that information to another employer or to your HR department unless you fit within an HIPAA exception, you've got the patient's authorization. So beware of that. Now, there's a couple of things that you can do. You can make sure that you condition the provision of that care or that vaccination or whatever on the authorization before you provide the service, so that you make sure that you've got the authorization so you can use it or disclose it. If you're an employer, you may condition their employment on the authorization. So just make sure that you're aware of those issues. Briefly about marketing. HIPAA applies to marketing. The general rule is for marketing, you've got to have the patient's authorization in order to use or disclose their information for marketing purposes. Marketing is generally defined as a communication about a product or service that encourages the recipient of that communication to purchase or use the product or service, okay? So anytime you're out there marketing stuff, you got to be concerned about HIPAA if you're using protected health information, including internally, you're using the patient's health information to market others, okay? Even the patient. Now, there's an exception though. Marketing excludes from the definition under HIPAA. HIPAA excludes from the definition of marketing any communication to describe a product or service as provided by the covered entity, or a communication for treatment or healthcare operations, or for case management, care coordination, and so forth. So HIPAA says those are not considered marketing, so you generally don't need the authorization for those types of communications. So you can use or disclose your patient's information to market your own products or services, or to tell them about another product or service that they may need for treatment purposes or those types of things. That's not considered marketing. But if you're out there just using their information to market to some other entity's products that's not really related to the healthcare of your particular rendering of healthcare for that person, it's not treatment for that person, then you generally need the patient's authorization. Now, even in those situations where you are marketing your own product, if you're having a third party pay you in order to market or make those communications, then it does become marketing and you generally need the patient's authorization. Let's talk briefly about personal representatives. Under HIPAA, you treat the personal representative as if they were the individual. That means because the individual has the right to access protected health information, the personal representative also has the right to access that information. That personal representative can exercise any of the rights that the patient has. So it's key to understanding who is a personal representative under HIPAA. Under HIPAA, a personal representative is a person who has the authority to make healthcare decisions for a patient or an individual. Makes sense. If they can make their healthcare decisions, they also ought to be able to make their decisions concerning their health information. So for example, in Idaho where I live, we have a statute that has a hierarchy of who can make healthcare decisions for the patient. If the patient's a minor or incompetent, in those situations, they would be the personal representative if their authority has been triggered. There are certain circumstances where it would allow you to disregard the person as the personal representative. So for example, if the minor has the authority to consent to their own health care, well, then you don't have a personal representative because the minor can consent to their own care. So that personal representative is not going to have the authority to consent to their own care. If the minor obtains care at the direction of a court or a person appointed by the court, if the patient agrees that the provider may have a confidential relationship, or excuse me, if a parent, in the case of a minor with a parent, if the parent agrees that the provider may have a confidential relationship, then you don't have to treat the parent as the personal representative. Or the most important one, if you determine that treating the personal representative as the patient is not in the best interest of the patient, then you can decline to treat that parent as the personal representative, for example, in an abuse case. For more information about making disclosures to families or friends, the government has published a helpful resource. That's pretty good. Sometimes, especially if you've got a parent who's complaining about, why can't you give me this information? You can send them that and they can be the bad guy. Brief word about business associates. HIPAA allows you to use or disclose protected information or disclose protected health information to business associates. You don't need the patient's authorization, but you do need to get a business associate agreement with that business associate. That's important because if you fail to have that business associate agreement in place, and if the business associate screws up and makes improper disclosures, then there are some OCR settlements that have basically held you liable for whatever the business associate did. I think that those are wrongly decided. That shouldn't come down that way, but nevertheless, they're out there. So you need to make sure that you've got valid business associate agreements in place. Remember, your business associates are basically any other entity that's using or disclosing your protected health information on your behalf, right? If you're hiring or paying somebody to use or disclose that information on your behalf, they're probably going to be your business associate, and you need to make sure that you have a business associate agreement in place. That business associate agreement has to contain certain terms and as set forth in the regulations. The government has actually provided you with sample business associate contract language. I draft my own. I don't like all the language that they've got in there, but it gives you a pretty good idea of what you've got. Again, like authorizations, periodically it's a good idea to call up and look at the requirements that have to be in your business associate agreement. They're set forth in 45 CFR 164, primarily in 0.504E. You'd want to make sure that those are in your business associate agreements. I've got an article on my website if you'd like that on a checklist for business associate agreements. HIPAA says that even if you're allowed to make these disclosures to a third party, you've got to take reasonable steps to verify that that person is who they are and that they're really entitled to access that information. HIPAA also says, even though HIPAA allows you to use or disclose this information, in general, you can't use more than the minimally necessary in order for that purpose. So make sure that you limit the amount that you're using or disclosing to the minimum necessary. There are exceptions to that. The minimum necessary standard doesn't apply to disclosures to patients or to other providers for treatment. You don't have to guess whether Dr. S really needs all of those documents. You can send them anything that they provide as long as it's for treatment purposes. A key point on the minimum necessary standard, this rule requires in your organization that you have role-based access policies where you supposedly have gone in there and identified the classes of employees and what types of information they're entitled to access. The rule specifically says you've got to have those policies in place. A lot of you probably don't, but that's something you may want to consider putting in place, because if you do have a rogue employee who accesses information improperly and you've got that policy and the OCR comes in to investigate, you can say, yeah, we had the policy. This guy just violated. They went rogue. We're not liable for what they do. You'll probably be okay. HIPAA also gives patients certain rights, including they have a right to receive that notice of privacy practices no later than the first date of treatment. Now, remember I mentioned the proposed HIPAA rules that were out there pending? One of those rules would modify the requirements in your notice of privacy practices, not only the terms, but also the requirement that you obtain the patient's acknowledgement of receipt of their notice of privacy practices. Right now, HIPAA requires that when the patient comes in, you've got to give them a copy of the notice of privacy practices or get their acknowledgement that they received a copy of it or it's been made available to them. Under the proposed rule, that would go away. You would still have to provide the notice of privacy practices, but you don't have to get their written acknowledgement, which would be a good thing. HIPAA also gives the patient a right to request restrictions on their use or disclosure of protected health information for purposes of treatment, payment, or healthcare operations. But remember, I said that HIPAA allows them to request those restrictions, but you don't have to agree to them. And my advice is don't agree to them because it's just going to increase your liability. There is one limited situation where you do have to agree, and that's if the patient pays for an episode of care themselves and tells you not to make a disclosure to a health insurer, a payer, third-party payer, then you've got to comply with that request. But again, that's usually a situation where you don't want to bring that up. If the patient asks you to do it, then you got to do it as long as they pay for the episode of care themselves. But you usually don't want to bring that up because it's going to place additional burdens on you and you're going to have to segregate the information. It's a whole mess. HIPAA gives the patient a right to receive communications by alternative means or at alternative locations. So if they want the information electronically and it's reasonable for you to provide that, you got to provide that in that format. HIPAA allows the patient a right to access information in their designated record set. I'm going to come back to that because that is a huge issue right now. HIPAA gives the patient a right to amend or request amendments to their health information, but you can deny that amendment for any number of reasons, including if the information was correct, but there's a process you have to go through and you have to give them notice and give the patient a chance to attach a statement of disagreeing with your determination. HIPAA requires you to, or allows the patient to get an accounting of disclosures of information that you've made. That's, at least currently, that's pretty much limited to just improper disclosures that you've made and certain disclosures that you made under 0.512, like to law enforcement and things like that. It's not just disclosures for treatment, payment, or healthcare operations. But watch for this, because under the HITECH Act, it would require entities that have electronic health records that they would have to account for even uses or disclosures for treatment, payment, or healthcare operations. The government issued a proposed rule on that years ago, but there was such a hue and cry that the regulations never came out. It's in the statute. We're going to have to comply at some point, presumably, but we haven't got the regulations on that. Just be aware of that. Let's talk briefly about some of those access issues. As I mentioned, the right of access is a huge issue right now. The government has, and they have for the last couple of years, an enforcement program going on to go after people for denying a patient's right to access their information. As part of that, the government issued guidance on the individual's right to access their information. This is required reading. If you haven't read that yet and you're a privacy officer or you deal with health information, make sure you go on there and you read that guidance because it sets forth the rules concerning access and how much you can charge patients for their records and when you have to provide it and what form and format you have to provide it. It's really important for you to understand those rules. Now, there's a change, though, in that guidance. In 2020, there was a case brought out by SIOX. It used to be in that guidance, and OCR had taken the position that a patient has a right to direct you to send their records to some other person, either paper or electronic records. And if you do that, then you're limited. You have to, the requirements that otherwise apply to the patient's access to information also apply to those requests to send that information over to another entity, including the limits on the amount that you can charge and those types of things. Well, the records company, SIOX, disputed that. They brought a lawsuit and they won. And the court modified the OC rules for disclosures per a patient's request to send PHI to a third party. So these are the current rules in the wake of SIOX. So if you maintain that information in electronic format, so for any ePHI, consistent with the HITECH Act and the current HIPAA rule, if a patient says that, hey, I want you to send my ePHI to another third party, you've got to do that. And you've got to do it within 30 days or the date permitted by HIPAA. We'll talk about the information rule or information blocking rule in a minute, but you got to comply with that. However, the HIPAA rules on the amount that you can charge for those disclosures or the amount that you can charge to disclose information to the patient or allow a patient to access, those would not apply to those requests to send the information to a third party. So you can basically charge that third party whatever is reasonable under the circumstances. That's not going to constitute a sale under HIPAA. Okay, so that's the rule for ePHI. If the patient requests for you to send ePHI to a third party, you got to do it. You don't have to have a written HIPAA authorization under the HIPAA regulations. All you got to do is have the patient's request and information identifying where it needs to go. For other types of records, not electronic records, but for other types of records, you're not required. HIPAA does not require you to send those records to a third party per the patient's request. You could decline to do so if you want. In addition, you could require the patient's authorization before you can send that, and again, you're not limited to that reasonable cost-based fee that you would otherwise, you're limited in the amount that you can charge the patient. So just beware of those rules. HIPAA also contains certain administrative requirements that sometimes get overlooked. Among other things, you've got to have a written designation of the person who is your HIPAA privacy officer and your security officer. So you should have some document somewhere in your organization that says, hey, this is my privacy officer, this is my security officer, that has their name. You've got to implement policies and safeguards that are required by the privacy rule. You've got to train your workforce, and you're going to want to document your training so that if the government comes in, you can say, look, we had the policies in place, we did the training, see, look at, and we just had a rogue employee, and we're not liable for what a rogue employee does. You've got to have you've got to respond promptly to complaints. You've got to act to mitigate violations. They don't tell you exactly what you must do, but you've got to take appropriate steps if there were violations. You've got to sanction workforce members if they violated HIPAA. If you fail to sanction them, if you fail to impose some kind of penalty, then you could be liable for a HIPAA violation. Now, that doesn't necessarily mean you have to terminate them out of the box, but at the very least, you're going to document some kind of warning, maybe have some HIPAA training or something that they had to participate in, suspensions, those types of things. But you have to document appropriate sanctions. And you've got to maintain the documents that are required by HIPAA for 6 years. That's not your medical records. We're talking about the documents that are required by HIPAA, things like patient authorizations, your notice of privacy practices, your business associate agreements, those types of things. As I mentioned, the government has proposed rules back in January of 2021. I have not seen anything recently concerning the status of those or whether or not they're going to actually promulgate. But there were some pretty significant changes. Most importantly, perhaps for most of you, they strengthened the individual's right of access. It would allow individuals to take notes or use other personal devices to view and capture images of PHI. So if they want to come in, they can bring in their cell phone and they can take photos of your hard copies. It would shorten the time for responding to the patient's right to request from 30 days down to 15 days. It would require providers to share information when they're directed by the patient. So, that SIOX decision I just talked about, you would basically throw that out, and under the new rules, it would basically say that you have to provide that information when directed by the patient. It would further limit charges for producing the protected health information. So you would restrict the amount that you can charge to patients or third parties. Other things are designed to facilitate care coordination with other providers. As I mentioned, it would clarify the ability to make disclosures to avert a threat of serious and imminent threat of harm. It would do away with the requirement that you obtain the acknowledgement of a notice of privacy practice, and it would modify the content of your notice of privacy practices. Again, I want to emphasize, we haven't got this rule yet, right? We don't know what form it's going to issue or when it's going to issue, but stay tuned, it may be coming down the pipe. All right, that's the HIPAA privacy rule. Let's talk about the security rule now. Privacy rule applies to all your protected health information in whatever format, electronic or paper or whatever format. The security rule only applies to your electronic protected health information. The security rule is designed to protect your information, not only the confidentiality, but also the integrity and the availability of your information, to make sure that a hacker doesn't get in there and corrupt all of your data, or that they don't hit you with ransomware so that you can't access your information. So what does the security rule requires? It requires that you perform a risk assessment to determine the needs for security steps and what is appropriate. You need to then implement certain administrative, technical, and physical safeguards that are put in place in the regulation. So you got to satisfy these specific administrative, technical, and physical safeguards for your organization. And you've got to execute business associate agreements that require essentially your business associates to comply with the security rules. I can't emphasize enough how important the security rules are given this era of cybersecurity problems that we've got going on right now. A key in order to protect yourself is make sure that you do that security risk assessment. When you look at the big ticket penalties that have been coming out or settlements for individuals, they almost always involve breaches of the security rule, and most of the time the government conclude that you didn't do an appropriate risk assessment. So you've got to do this risk assessment. It's not a one-time deal. you should have a periodic process for ongoing risk assessment. Probably at least annually, you need to periodically do a risk assessment because your health information system changes all the time, right? You get new devices, you have new laptops, you have all these other things going on. So you need to make sure that you've got an ongoing risk assessment. The government has, to help you, provided you with a risk assessment tool that will help you do that risk assessment. It's free. You can pay a consultant, tens of thousands of dollars to do it for you, or you can go on the government's website there and you can use that security risk assessment tool. The government has a bunch of other resources available to help your IT people comply with the security rule. There's healthit.gov has a bunch of stuff. Also, the OCR site has a bunch of resources, including technical guidance and the like. A couple of issues concerning the security rule. One is encryption. Remember that encryption is an addressable standard under the rule. It means that you don't have to do encryption, but if you're not going to do encryption, then that means that you would have to come up with another means of securing your information that's as safe as encryption, and it's otherwise not reasonable for you to do encryption. That's a hard standard to satisfy. So assume that really all of your electronic protected information should be encrypted. Now, that's not information that just goes outside. That's not just information you put on a disk or in a thumb drive and give to somebody, but it's even the information internally should be subject to encryption. That is the standard. The presumption is that you're supposed to do that. Now, the benefit is that electronic protected health information that is encrypted is considered secure. That means if you lose it or if there's a breach, there can't be a breach of it because it was encrypted. It's secured, and therefore it's not subject to the breach reporting rule. The Office for Civil Rights assumes that if you have a loss of an unencrypted laptop, USB, or mobile device, you've got to assume that that's going to be a breach. Even if you don't know where it went or have no evidence that it was improperly accessed, the Office for Civil Rights has historically said that you have to assume that there's been a breach. That means that you'd have to do the report to everybody whose information was on that laptop, which could be, thousands of people. Now, in the recent HHS versus MD Anderson case, the court rejected that position, but that's in the Fifth Circuit. If you're outside the Fifth Circuit, that's not necessarily precedent. So the OCR still takes the position, it appears, that you got to assume that if you lose an unencrypted laptop or an unencrypted phone or device that has PHI, that it's probably going to be reportable. When it comes to those mobile devices, be really careful about that. Those are everywhere these days. Make sure employees aren't taking photos, making sure if you're texting back and forth using those mobile devices, the general rule is those have to be encrypted. Let's talk briefly about communicating via email or text. The rule here is generally under HIPAA. Remember, electronic protected health information has to be encrypted. That means if you're communicating back and forth with patients or payers or healthcare providers, that is supposed to be encrypted. Now, in the communication back and forth with the patient, the government has said, remember, the patient has the right to request communications by alternative means or at alternative locations. So that patient can agree, they can request to get information in an unsecure manner. So HIPAA says, the OCR says, yeah, you can communicate with a patient via unsecure email or unsecure text, as long as you warn the patient and the patient agrees. As long as you warn the patient that it's not secure and the patient wants to get it that way, then that's okay. You would probably just want to document it to protect yourself. When it comes to other providers, other physicians and the like, that same rule doesn't apply. The general rule is you got to have an encryption solution so that they're not texting back and forth protected health information or emailing through an unsecured network. Let's talk briefly about cybersecurity, because this is a huge issue right now. As many of you know, some of you have probably been hit with ransomware attacks. It is a huge, huge problem. And think about the potential consequences. If you can't access your information, patients could die. You could be subject to malpractice. You can't bill. How are you going to provide effective care? It's a terrible issue. And the government has really stressed this when it comes to healthcare entities, particularly in the first quarter of this year. The new Office for Civil Rights director, Lisa Pino, actually came from the government's Homeland Security Department, where she dealt with cybersecurity issue. And so it's a real focus for her. In February, she issued a blog post to all healthcare providers, everybody covered by HIPAA, in which she said, "I cannot underscore enough the importance of enterprise-wide risk analysis. You should fully understand where all your electronic protected health information is and take appropriate steps. Some best practices include maintaining offline encrypted backups of data and regularly test your backups so that you can protect against ransomware, conducting regular scans to identify and address vulnerabilities, especially those on internet-facing devices, to limit the attack surface, regular patches and updates of software and operating systems, and training your employees regarding phishing and other common IT attacks." The government's putting you on notice, right? You got to take this stuff seriously. In Q1 of this year, the OCR issued its quarterly letter, and the newsletter specifically addresses these cybersecurity issues, including phishing, exploiting known vulnerabilities, weak cybersecurity practices, and it provides a whole list of resources. If you haven't looked at this yet, you really ought to download this and take a look at it. Make sure your IT people know about this and they look at it, because it really is a helpful resource. The government has a bunch of other stuff out there. They've got a specific website dealing with ransomware, because healthcare providers are such a huge target for ransomware right now. I think it's the biggest industry sector right now that's targeted by ransomware. So the government has these websites where it has a bunch of resources. They've issued guidance for you. Here's another very helpful resource that has best practices for identifying the top risks and what you need to do to protect yourself against it. The government also has established its HC3 website, which is kind of like the ongoing, latest breaking news on cybersecurity threats. So you should make sure that your IT people are aware of this website, that they regularly check it so that they're aware of, they stay current on the threats that are out there and can take appropriate steps. All right, that's enough about the security rule. Let's talk about the breach notification rule. Under the HIPAA, if there is a breach of unsecured protected health information, then you've got a narc on yourself. You've got to notify the individual who's affected. HHS, you also got to notify them. And if the breach involves more than 500 persons, you've got to notify you've got to notify local media. The key there is identifying whether there's a breach of unsecured protected health information, because it only applies if it's a breach of unsecured protected health information. Well, if the information is secured, it's not a breach, so you don't have to report it. So if the information was encrypted, consistent with HIPAA standards, you don't need to worry about breach reporting. If, on the other hand, it was not secured, then the question is whether or not there's a breach. A breach is defined as the acquisition, access, use, or disclosure of protected health information in violation of the privacy rule. So it only applies to breaches of the privacy rule, not necessarily the security rule. If there's an acquisition, access, use, or disclosure of PHI in violation of the privacy rule, it's presumed to be a breach unless the covered entity or the business associate can demonstrate that there's a low probability that the information has been compromised. That's the standard. Was there a low probability that the information has been compromised? How do you determine that? Well, you look at you do a risk assessment based on the following 4 factors, including the nature and extent of the PHI involved, who got the information, who was it that received it, whether the information was actually acquired or viewed, and the extent to which the risk to the PHI has been mitigated. So those are the factors that you determine whether or not it is a reportable breach. You do that analysis. I don't have time to go through it all today, but I've got an article on my website that talks about applying those standards. If there is a breach, then you have an affirmative obligation to NARC to the individual. Let me point out this. In close cases, if you're not quite sure whether or not there was a breach, the general rule is you're safer in making the report, because the government has said, look, if the government gets hundreds of thousands of breach reports, right? And they haven't got time to track down all of them. So as long as you do the breach report, chances are, unless it's pretty egregious, the government's never going to look at it and you're going to be fine. And it's not going to be, and even if they did, it's probably not willful neglect. But the government has said, if you fail to make a report, even though the breach itself was not caused by willful neglect, if you fail to make the breach report, that may be willful neglect. And therefore, the government can come after you for all of those penalties that we talked about. So in a close case, I usually err on the side of making the breach report. I think you're probably going to be safer in those, because I'm concerned about a situation, especially if a patient knows about it, that they're going to turn it into the government. If the government shows up, they're going to want to know why you didn't make the breach report. And if you haven't got a really good explanation, then you could be hit up for for willful neglect sanctions. So my general rule is in close cases, make the report. When you make that report, you've got to do it without unreasonable delay, but no later than 60 days from the date of discovery. And that means from the date that anybody in your organization, other than the breaching party, anybody else knew about the breach. Now, note that that's no later than 60 days. If you can complete your analysis, so you've got the things you need to make the report within 5 days, you need to make it at 5 days. It doesn't mean that you always get the 60-day period. You've got to do that. In making that report, you've got to provide a written report to the individual by mail, unless you get the patient's consent to give it to him by email. And that notice to the individual must contain required elements, including the description of the breach, the actions you took in response, and suggested action they may need to take in order to protect themselves. When you do that breach to the patient, you're always going to have to also give notice to the government. The only question is the timing. If the breach involves fewer than 500 persons, you can wait till 60 days after the end of the calendar year, so you can report, anytime between up until March 1st of the subsequent calendar year. On the other hand, if the breach involves 500 or more persons, then you've got to notify HHS at the same time you notify the individuals, i.e. basically within that 60-day window. You make that breach report by going to the government's website here, and you submit it in online. If the breach involved more than 500 people, you get added to the government's wall of shame. If the breach involves more than 500 people, 500 residents in a state, then you've also got to notify local media, and there's a process under HIPAA for doing that, the types of information you disclose. Just make sure that when you do that notice to the media, you don't disclose protected health information to the media. Don't compound the problem by disclosing patients' information. Business associates are obligated to notify the covered entity, but ultimately it's the covered entity's responsibility to make the report to the government. They can delegate it to the business associate, but they better darn well make sure that the business associate does it correctly, because it's the covered entity that's going to be responsible if they fail to do it. A lot of times under HIPAA, the business associate has 60 days in order to make the report. Usually you want to make sure in your business associate agreement you don't give them that much time. You want to make sure that they make the report sooner to you so that you can take appropriate corrective action to stop the breach within that 30-day period to mitigate the breach so that it doesn't get out of hands, and therefore you can avoid the penalties. Remember, we talked about the HIPAA breach reporting. Remember that your state may have its own breach reporting. This is a little bit aside from the HIPAA stuff, but there's a model act that most states have adopted that generally state that if you have any commercial entity that has a breach of a computer system that results in the illegal acquisition of certain unencrypted computerized personal information, usually involves name plus an identifier, an account number, social security number, that type of stuff. If you've got that, then you just generally have to do a breach report. If you fail to do that, then you can get hit up with fines or other sanctions from the Attorney General. At least according to the Model Act, if you comply with HIPAA in making your disclosures, that satisfies the requirements under the state law, but you need to check your own state law on that. All right, that is HIPAA. Let's talk about the information blocking rule. This is a new rule that came out. The government wants to promote, a more efficient care, and they think we can do that by sharing the information. And they're concerned about situations where instead of sharing the information, people are blocking access to that information. They're not sharing the information, which is contrary to the government's whole purpose to share health information in order to have better outcomes. And therefore, they came up with the information blocking rule. It applies to actors, which includes healthcare providers, not just healthcare providers who develop their own IT. It's any healthcare provider who has electronic protected health information. You guys are subject to the information blocking rule. It also applies to developers or offerers of certified health IT and health information networks or exchanges. What does it do? It prohibits those actors, including healthcare providers, from engaging in unreasonable information blocking, which is a practice that is likely to interfere with the access, exchange, or use of electronic health information. And electronic health information basically is any information, like it says, any electronic health information that would be in a designated record set. If you do that, if you engage in that information blocking, and you know You as a provider know that the practice is unreasonable and likely to interfere, then you can be subject to sanctions. The standard is a little bit different for developers of health certified IT, which could be you if you developed your own IT, your own health IT. If for those guys, these rules apply if they, not only if they know, but if they should have known that it was likely to interfere, then they can get hit up with penalties. What are the penalties? Well, for developers of software, health certified IT, or health information networks or health information exchanges, they can get hit up with up to $1 million penalty. That's actually been increased because of the cost of living adjustment. For healthcare providers, we don't know yet. We haven't got the enforcement rule. The government has said that they'll include appropriate disincentives that are supposed to be established by HHS, but we're waiting for the rule. This may be why you haven't worried too much about the information blocking rule yet, because they haven't got an enforcement penalty out there against you, but be careful because it's coming down the pipe. And remember that HIPAA, if you violate HIPAA, if you violate another state law that provides additional protection, well, the health information rule may provide additional protection now. Therefore, if you violate the health information blocking rule, you may be deemed to violate HIPAA. So you could be subject to those other penalties. The bottom line is you need to take the health information blocking rule seriously. What are some examples of information blocking? Well, it could be refusing to timely respond to requests, charging excessive fees, imposing unreasonable administrative hurdles, imposing unreasonable contract terms, implementing health IT in non-standard ways that increase the burden, anything else that's unreasonably that gets in the way of sharing this protected health information or blocking access to this health information. It's not information blocking if the action is required by the rule. So if the law prevents you from making the disclosure, for example, HIPAA prevents you from making the disclosure, then it's not information blocking if you refuse to make it. If 42 CFR prohibits you from making the disclosure, it's not information blocking if you comply with the law. So you're never violating HIPAA or violating the information blocking rule if the law prohibits you from making that disclosure. On the other hand, if the law allows you to make the disclosure and you just simply decide not to, then it can be information blocking. So for example, under HIPAA allows you to make disclosures for purposes of treatment, payment, and healthcare operation, but it doesn't require you to do it. The information blocking rule prohibits you from unreasonably blocking access. So it may effectively require you to allow that access to that information, even though you're not required to under HIPAA. So make sure you're aware of those issues. So it's not information if the action is required by law. If the action is reasonable under the circumstances, remember that's the test, right? Was the information blocking reasonable under the circumstances? Or it's not information blocking if you fit within a regulatory exception. And there's a number of safe harbors that you could fit within, but those are somewhat difficult to fit those safe harbors. You should be aware of them, but it's somewhat difficult to fit those. The government has a lot of good information on information blocking. You can go to this website. It'll give you more information, more guidance and direction. I did want to point out a couple of interesting FAQs that the government posted. Among other things, they said, are actors, for example, healthcare providers, expected to release test results to patients through a patient portal or application programming interface as soon as the results are available to the ordering clinician? A lot of you probably have policies that, no, you don't release those to the patients until the treating physician has had a chance to review those. Well, guess what? The government says that that you may not be able to do that. You shouldn't do that. They said that while the IBR does not require actors to proactively make electronic health information available, once a request to access, exchange, or use is made, they must timely respond. In practice, this could mean a patient would be able to access electronic health information such as test results in parallel to the availability of the test results to the ordering clinician. That's a sea change for a lot of you, and you need to consider the ramifications of that. Now, in an earlier version of the FAQs, they said, the question was asked, do we have to engage in, put in place a portal? Does it require us to put a portal in place? And in that FAQ, the government said, no, there's nothing that affirmatively requires you to, on your own initiative, to send this information out to the patient. It just says that if the patient asks for the information, you can't engage in blocking, you would need to provide it. But it doesn't affirmatively require you to send this out. But they took that down. They took down that FAQ and they replaced it with this, which suggests that if that information is available through the portal, then you got to be able to, the patients should be able to access it immediately. Elsewhere, similarly, they said the following. When would a delay in fulfilling a request for access to EHI be considered an interference under the IBR, under the information blocking rule? They gave this example. If a healthcare provider, it's likely to be an interference if a healthcare provider established a policy that imposed delays on the release of lab results for any period of time in order to allow an ordering clinician to review the results, or in order to personally inform the patient of the results before a patient can electronically access such results. It also would likely be considered an interference where a delay in providing access occurs after a patient logs into a patient portal to access electronic health information that a healthcare provider has, including, for example, lab results. And such EHI is not available for any period of time through the portal. That's a big change. I think they've overstepped here, but nevertheless, that's the standard, at least they think, that if you've got that information on your EHI, it should be linked to the portal and the patient should be able to access that immediately. Bottom line is you'll want to look at that. Another interesting FAQ. They state that when a state or federal law or regulation, such as HIPAA privacy rule, requires electronic health information to be released no later than a certain date after request is made, is it safe to assume that any practices that result in the requested EHI's release within that other required time frame will never be considered information blocking? What does that mean? HIPAA says you can allow access, you have 30 days to allow access to the patient. The information blocking rule says, no, you can't engage in unreasonable delays. That means that you can't rely on the 30-day time limit under the information blocking rule. The information blocking rule has a separate requirement that says you can't impose unreasonable delays. And if 30 days probably is an unreasonable delay. So you can't rely on that 30-day limit in HIPAA. So when you're talking about the information blocking rule in HIPAA, just remember that the more restrictive law controls. If HIPAA allows access or disclosure, remember the IBR prohibits information blocking. That means the IBR may require the provider to allow access or disclosure even if HIPAA does not require it. For example, in the case of treatment, payment, healthcare operations, or if the patient gives you an authorization. That may, in addition, the information blocking rule may require you that you respond more quickly than HIPAA would. That is, you may not be able to wait 30 days to provide access to that information as you have under HIPAA. On the other hand, if HIPAA or another law prohibits disclosure, then you can comply with that law, right? The IBR doesn't require you to violate the law. If the law prohibits you from making the disclosure, then the IBR says, fine, you don't make the disclosure. So for example, under HIPAA, if it says you can't make the disclosure without the patient's authorization, then you don't have to make the disclosure unless you get the patient's authorization or patient consent or one of those other situations. All right. We are right at the hour mark. For those of you who are not covered by part 2, feel free to go ahead and jump off. Otherwise, I'll take about another 15 minutes and just talk about some of the part 2 issues. This applies to substance use disorder records. Substance use disorder records get super protection under state and federal law. Those are the laws that potentially apply. Now, the whole purpose behind that, years ago, the government wanted to encourage people to get substance use disorder treatment. And they were concerned that they would not seek substance use disorder treatment if it was going to be accessible by law enforcement or by others. And therefore, in order to encourage people to get that substance use disorder treatment, the government put in place protections, particularly 42 CFR Part 2, that says that if you've got a Part 2 program, a federally assisted drug substance use disorder program, then that program can't disclose the information, the SUD information, unless they satisfy certain requirements. Now, it not only applies to that Part 2 program, but it applies to the records. So if those records go someplace else, then the recipient of those records also generally has to maintain the confidentiality of that, subject to certain limitations. A couple of updates concerning Part 2. Back in March of 2020, the government issued the CARES Act, and that modified the substance use disorder records. Subsequent to that, SAMHSA, the entity that's responsible for implementing the Part 2 requirements, they also made regulatory changes. Let's talk briefly about both of those. That CARES Act that came out in 2020, some significant portions of that. The most significant, I think, for most of you guys is that it now allows the disclosure of SUD information for purposes of treatment, payment, or healthcare operations, so long as you obtain the patient's initial consent. So they tried to drive this to make it coordinate more with HIPAA. So just like under HIPAA, you can use or disclose the information for treatment, payment, or healthcare operations. Under they changed the law now for 42 CFR Part 2, or at least the law that supports that, and said if you get the patient's consent at the initial, when they first come into the SUD program, that patient can go ahead and authorize you to use that information so long as it's for treatment, payment, or healthcare operations. This is a big deal for you that are SUD entities. That means that when your patient comes in, you're going to want to have them sign a consent, an effective consent that allows you to use or disclose their information for treatment, payment, or healthcare operations, because it's going to free you up to make disclosures and uses of that information in order to get paid, to coordinate care with others, those types of things. So this is a huge issue for you. We'll talk more about this briefly. All right, the next thing is it replaces the criminal penalties with HIPAA penalties. It used to be if you violated Part 2, then you could go to jail for that. They've thrown away all those criminal sanctions. Now they treat it just like a HIPAA violation. So if you violate Part 2, you can be hit up with those same sanctions that would apply to the same civil penalties that would apply to violations of HIPAA. Okay, so you treat them the same. Of course, a violation of Part 2 is also going to violate HIPAA anyway, so it's not much different. But we now don't have to worry about the criminal sanctions. We just have to worry about the HIPAA sanctions. And it requires breach notification for improper disclosures of SUD information. So again, they're kind of coordinating it with HIPAA. And so just like under HIPAA, you'd have to give the breach notification. You'll have to give the breach notification under Part 2. That's really not a big change because, again, if you violated Part 2, you violated HIPAA, and you would have to give the breach notification under HIPAA. They just make it clear now that you have to give the breach notification under Part 2 also. There are other changes, but those are the most important. Now, like I said, we do not have the regulations yet incorporating these CARES Act changes. SAMHSA has not issued those. So even though we've got a statute that says you can get that consent and use or disclose the information for treatment, payment, or healthcare operations, we don't have the regulations yet. So be careful about that. It's really important. Hopefully SAMHSA will get those to us because that's an important change. SAMHSA did come out with new regulations in 2020, but they addressed other stuff, primarily coordination of care type issues, to make it a little bit easier to coordinate care between SUD entities and other entities, but they don't address the CARES Act provisions. So we've got to watch for that in case those, if and when those come out. Let's talk about Part 2. As I mentioned, it generally prohibits the use or disclosure of records without the patient consent if the record identifies a patient as having had, or even if they don't have it, if they were referred for a substance use disorder, and the SUD record is created, obtained, or maintained by a federally assisted drug or alcohol abuse program, or an SUD program. That is the key for most of you. Are you going to be subject to Part 2? Are you a federally assisted drug or alcohol abuse treatment program? Well, there's two parts to that. First, you have to be federally assisted. The second is you have to be a drug and alcohol treatment program. Federally assisted, if you're participating in Medicare or Medicaid, you're federally assisted. It applies to almost everybody. If you're purely private pay, maybe you can avoid it, but pretty much everybody else. If you're licensed as an SUD program, if you are receiving any money from the government through Medicare or Medicaid, you're federally assisted. So usually it comes down to this. Are you a program? Well, what is a program? A program is an individual or entity other than one in a general medical facility that holds itself out as providing and provides SUD diagnosis, treatment, or referral, or it's an identified unit in a general medical facility that holds itself out as providing and provides SUD diagnosis, treatment, or referral, or medical personnel in a general medical facility whose primary function is providing SUD diagnosis, treatment, or referral, and who are identified as such providers. So the rules differ depending on whether or not you're with a general medical facility or another entity, right? General medical facilities are hospitals, trauma centers, FQHCs, maybe primary care practices, the types of practices that don't just focus on providing SUD. They've got a wide range of services. SUD may be part of it, but it's got a wide range of other stuff too. And the rules differ depending on whether or not you are a general medical facility or not. This chart, I think, is helpful. So if you are an individual or entity that is not affiliated or in a general medical facility, then the test is this to determine whether or not you're a program. So part 2 is going to apply to you. Do you hold yourself out as providing SUD diagnosis, treatment, or referral or treatment? And do you provide SUD diagnosis, treatment, or referral? If so, then you're a program and you got to comply with part 2. On the other hand, if you are at a general medical facility, like a hospital, an FQHC, or other entity like that, it depends on whether or not you're in an identified unit or your medical personnel. If you've got an identified unit in that general medical facility, and that identified unit holds itself out as providing SUD diagnosis, treatment, or referral for treatment, and it actually provides SUD diagnosis, treatment, or referral, then that identified unit within that medical facility, that unit is going to be a program, and it's going to have to comply with part 2. Alternatively, or in addition, if you've got, even if you don't have an identified unit, if you've got specific medical personnel in a general medical facility whose primary function is to provide SUD diagnosis, treatment, or referral for a treatment, and they are identified as such providers, they identify them as this is our SUD person in our facility, then that person would be a program, okay? Now, it's important to note here that if you're a general medical facility, it's only that identified unit or those persons who are the program. The rest of the unit, the rest of the facility is not an SUD program. That means that that program, that individual or that identified unit will have to separate and segregate its information and put up the 42 CFR Part 2 blocks before it can share information with the rest of the organization. Now, a lot of these tests depend on whether or not you hold yourself out as providing SUD information. Hold yourself out as is defined as any activity that would lead one to reasonably conclude that that individual or entity provides SUD diagnosis, treatment, or referral, for example, through advertising or marketing. In the commentary that SAMS has issued, they said that it also may include state licensing procedures. So if you go through and get licensed to provide SUD information, or you advertise or post notices, certifications in addiction medicine, listings in registries, internet statements, consultation activities for non-program practitioners, information presented to patients or families. If you're actually out there kind of holding yourself out as providing this SUD information, then you may be a Part 2 program. Part 2 program generally is not just emergency personnel who are within a general medical facility who happen to treat an overdose. They're not holding themselves out as it's not a program that provides SUD information, even though they are providing specific treatment. Similarly, providers who prescribe controlled substances to treat SUD, but who do not otherwise hold themselves out as providing SUD treatment. So they may treat a particular patient, but they're not otherwise advertising or hold themselves out as SUD providers, then they would not be a program. All right, so if you are a program, then you have to comply with the Part 2 requirements, the 42 CFR Part 2 requirements. It also applies to entities having direct administrative control over the Part 2 program. They have to maintain the confidentiality. And any lawful holders who get those SUD records from a Part 2 program, they also have to comply with Part 2. That's basically another entity who receives information from a Part 2 program, along with a notice that the Part 2 program has to send out that says that this information is protected by Part 2 and you've got to maintain it. Even if you're not a Part 2 program, if you get that information from a Part 2 program, you got to maintain the protection, that confidential information, and maintain the confidentiality of it. What are the general rules? Well, you can make disclosure of SUD info with the patient's consent, written consent. Remember that I mentioned at least under CARES Act 3221, which is the current law, so assuming you can do it. You can make disclosures as long as you've got the patient's written consent for treatment, payment, or healthcare operations, or for any other purpose that is specified in the consent, but that consent has to contain required elements that are set forth in the regulations. And that consent has to include a notice prohibiting any kind of re-disclosure that would go out to some other person. Part 2 would also allow you to make certain disclosures without the patient's consent, including you can use the information within the Part 2 program if there's a need to know. You can disclose Part 2 information to those with administrative control over the Part 2 program. You can also disclose information to a qualified services organization that's providing services to the Part 2 program, but you've got to have an agreement with that qualified service organization that they'll treat the information confidentially. It's basically like a business associate arrangement and a business associate agreement for under HIPAA. Part 2 would allow you to make disclosures in a medical emergency, to report certain information to law enforcement if there was a crime committed on the premises on your Part 2 program, to report child abuse, research subject to, there are certain limits. You can disclose it for research purposes, but it's subject to certain conditions that you have to satisfy. You can make disclosures to audits and investigations subject to certain conditions in the regulations, or if you get a compliant subpoena that's accompanied by an order. Part 2 is different than HIPAA. HIPAA allows you to make disclosures per subpoenas if certain conditions are satisfied, but under Part 2, a subpoena alone is not enough. Court order alone is not enough. You got to have a court order plus a specific type of subpoena that allows you to make the disclosure. If you do go ahead and make the disclosure to another third party pursuant to the patient's consent, you've got to send, along with that, those records, you've got to include a notice that either contains the long form or the short form. The short form is just simply, you can say that 42 CFR Part 2 prohibits unauthorized disclosure of these records. So it puts the person who receives that information on notice that they can't make further disclosures. Just like under the HIPAA minimum necessary standard, Part 2 says that any disclosure of SUD records must be limited to the information that's necessary to carry out the permitted purpose. So you can't use more than minimally necessary. If you give that information, you make a proper disclosure to a lawful holder, which is the person who's received that information appropriately. Part 2 would allow that lawful holder to go ahead and make further use or disclosure of that information for its own payment or healthcare operations, but only if certain conditions are satisfied. In addition to the confidentiality requirements, just like under HIPAA, you've got to give the patient a notice of privacy protections. Under Part 2, you've got to give a notice to your patients of their confidentiality protections under Part 2. You would have to actually give both a HIPAA notice and a Part 2 notice, or you would merge them in order to have one notice that contains the required elements for both Part 2 and a notice of privacy practices. That has to basically summarize the issues that are included on that slide, gives them information concerning the rules that apply to them and so forth. Under Part 2, it says that a patient may provide, Part 2 program may provide a patient with a copy of access to the patient's own records. So it's permissive, right? You may provide the patient with access. But remember, HIPAA, what is HIPAA required? HIPAA says that you must provide the patient with access unless you fit within certain exceptions, okay? In that situation, you would go with the more restrictive statute, which would be HIPAA. So even though HIPAA Part 2 says you may provide it, under HIPAA you must provide it, and in fact under the information blocking rule, you must provide it probably within a shorter period of time. Just like the HIPAA privacy rule or the HIPAA security rule, it requires you to put in place certain cybersecurity protections. Under Part 2, it also requires Part 2 programs to implement security protections. Unlike HIPAA, it's not as specific concerning what you need to do, but because most of your Part 2 programs are going to be have to comply with HIPAA anyway, then if you're complying with the HIPAA security rules, you're probably also going to be complying with the Part 2 security requirements. That is a very brief overview of Part 2. I've got additional information on my website, including a specific webinar dealing with that particular issue, but the best resource for Part 2 is you can go to SAMHSA. They've got a bunch of guidance concerning it, including how to identify whether or not you are a Part 2 program. All right, we have gone a little over the hour. I apologize for that, but we had a whole lot to cover. If you need additional guidance or discussion concerning any of these items, HIPAA, Part 2, those types of issues, that's a particular interest in mine, and therefore I've got a lot of free resources on our website. You can go to our website, you can access articles on a whole variety of HIPAA issues. There's sample forums and the like. Also information concerning Part 2. You can also access our past webinars dealing with HIPAA, breach reporting, Part 2 issues, those types of things, information blocking rule, all of that's available for free on our website. You can just access that. Thank you all for participating today. Hope it's been helpful. If you have any questions, feel free to reach out to either myself or my associate, Allie, and we would be happy to respond. And, I wish you the best of luck out there. Thank you.